You are listening to the Advocates of Aging podcast. This podcast is produced by the ABA Commission on Law and Aging. Listen to hear interviews and stories on topics related to law and aging, including best practice tips for professionals and career advice. Age is not just a number, it is an opportunity for growth and fulfillment. These episodes will explore the hurdles people face when aging, as well as opportunities for improving advocacy and strengthening the legal rights of others. Hi, my name is Erica Costello, and I, along with Tricia Bullock, are with the American Bar Association's Commission on Law and Aging. You are listening to our Advocates of Aging podcast. Today we have with us Erica Wood, Sally Hurme, Dr. Pamela Teaster, and Dr. Carlisle Shealy, who recently published a report entitled Environmental Scan of Guardianship Abuse and Fraud. A copy of this report and their bios will be provided in the podcast notes on our website. Thank you so much for joining us today. I'll go ahead and begin with our first question. So what prompted the Department of Justice to request you to conduct this research study?
Thanks so much, Erica and Tricia, for having us and really shining a spotlight on the guardianship research that we've done for the Department of Justice, the National Institute of Justice. Before we begin, I just wanted to say a word about terminology, because guardianship terminology varies by state. And so in many states and in a model law, decisions concerning healthcare and personal matters, the term used for that is guardianship, whereas for money and property issues, the term is conservatorship, and other states have different names. For example, in California, the term is conservatorship of person and property. So for this podcast, we're going to use the general term guardianship to refer to decisions about both healthcare and personal care, as well as finance and property. So what prompted the request by the Department of Justice? Well, kind of in a larger sense, the Department of Justice was responding to all of the increased focus nationally on how guardians do their job and to what extent they really abide by their fiduciary duties, and that how this affects vulnerable adults. And so it certainly is a question of justice, and so it's very appropriate, we think, certainly, that the Department of Justice study it. And of course, the Britney Spears case was a hot topic, as everyone knows, and there have been many continually there are media stories, and there's even been a movie about bad guardians. So it has been certainly on the radar screen. But the immediate trigger for the research was a June 30th, 2021 letter from Senator Robert Casey and Senator Elizabeth Warren to the U.S. Attorney General at DOJ and to the Secretary of Health and Human Services. Now, the letter asked for information about the role of the Department of Justice and HHS in collecting data on guardianship and supporting adults who are subject to guardianship. The letter recognized that adult guardianship, of course, is a state issue, but yet the federal government has a role in data collection and in information sharing, moving towards uniform policies and things like that. So this letter had a whole list, quite a long list, of challenging questions like, do these federal agencies, that is DOJ and HHS, do these agencies know or can they find out the number of adults subject to guardianship in the country, the number of guardians, the value of assets controlled by the guardians, the number and kind of the complaints about guardians, the number of sanctions about guardians, and any data about the use of less restrictive options and restoration of rights by ending a guardianship order. So that's a whole lot. But the letter also asked, does your agency collect information to find out whether guardianship is really benefiting those it serves? In other words, in the big picture, does guardianship help those it's supposed to be serving, kind of the outcome? And then what efforts to prevent guardianship abuse are underway, and what resources are needed from Congress? So this, as you can imagine, is a really tall order. And so the National Institute of Justice at the Department of Justice contracted out to us what they called an environmental scan. I had to look that up. An environmental scan to help answer these questions that were in the letter about what the Department of Justice and the federal government should be doing.
Thank you so much for providing us with that background information. So why is this work important in the guardianship field?
Well, one of our subject matter experts that we interviewed succinctly framed this issue as the following. If you want to understand a system, you have to be able to collect data. Thanks to Anthony Palmieri for summing up for us why data is so important to the guardianship field. So we've heard incidental stories about how the guardianship system is broken and proliferates with abuse by guardians. State and federal legislative hearings, as well as governmental investigations, have tried to get a handle on what might be flawed in guardianship. The common result really was for them just to throw up their hands and say, we don't know, because we don't have any data. The list of what we don't know is lengthy and very telling, and it goes along with the questions that the senators asked. We don't know how many adults have guardians. We don't know whether those individuals needed a guardian. We don't know who's serving as guardian and why they were selected and how they are performing. We don't know whether the guardianship was actually necessary for the well-being of the adult. We don't know whether the adult is better off because of the guardianship. And we don't know whether or how much abuse is happening. Because we don't know so many important aspects of guardianship, we cannot begin to understand what systematic changes are necessary, or what would be most effective, or where to allocate resources, or how to frame the best legislative reforms. If abuse is prevalent or even anecdotal, we, the advocates, the judges, court staff, guardians, and legislators, want to firmly address its causes and take the appropriate measures of prevention. To do so, we need data. In our environmental scan, we dug deeply into the factors that are limiting our ability to gather data, highlighted projects that are making important strides to answer some of these basic but vexing questions, and recommended some steps the federal government could take to move forward to better understand the system with critical data collection and ability to make an analysis and judgment from them.
Thank you, Sally. So tell us about your steps to completing this work.
So we followed a mixed method, multi-phase approach to complete the work. And the first step in that was to do a literature review, looking at many databases using various keywords such as guardianship, conservator, abuse, neglect, and exploitation, and fraud. And we reviewed an array of publications from many different sources, in doing so, including the federal government, such as testimony before congressional committees. We looked at 4 different national guardianship summits, reports on guardianship published by state governments, appellate court cases involving fiduciary misconduct. We also looked at peer-reviewed research on guardianship, and we also looked at more than a decade's worth of media accounts on guardianship abuse. And so that made up our first phase of the work. In our second phase of research, we conducted a scan of the guardianship abuse and fraud data landscape. And in doing so, we wanted to identify data elements that were necessary to tracking abuse and fraud by guardians. And our goal in this second phase was to be able to describe how states process cases, collect data, and identify the associated barriers to data collection. And we accomplished this by conducting key informant interviews as well as distribution of a survey. So a combination of qualitative and quantitative data, both of which were directed at the offices of state court administrators. The survey we developed was based on the themes from the interviews, which was pilot tested. And then we emailed these to points of contact from a list of state court administrators, as well as a list of state guardianship experts. And this list, we were fortunate, was provided by the National Center for State Courts. And the two lists together totaled more than 200 individuals that were knowledgeable about guardianship issues, monitoring, and data. And this was completed between July and September of 2022. In total, 34 people responded to the survey, representing responses from over 20 states.
Interesting. So what did you find in your literature review?
Tricia, thanks for asking. So we looked first at elder abuse, the elder abuse literature, and that had mixed information. 1 in 10 community dwelling elders, a study by Rana Cherno in 2020, had experienced abuse, not necessarily guardianship abuse. 2011, the National Center for State Courts did a guess based on 4 states, and that was 1.5 million, revised that in 2016 to 1.3 million open guardianship cases. But again, these are mixed. They are not based on a lot of good data. Then, of course, as mentioned earlier, my colleagues, 7 U.S. congressional hearings over 30 years, but not very much about the scope and prevalence of abuse by guardians. The GAO completed 5 reports on adult guardianship again, but those reports talk more about the need than they do about the scope of the problem. Other federal findings were Administrative Conference of the United States, a study done by the National Center for State Courts at the behest of the Social Security Administration. And that particular work, again, revealed we got a problem. We don't know what it is. We don't know the scope of it. The National Council on Disability also looked at unnecessary guardians, but did not, again, look at the scope. Media accounts mentioned before tend to be important starting in the 80s. But still can't really tell us definitively about the scope of it. And then conservator exploitation background briefs that were again done by the National Center for State Courts probably looked at media at the most, if we could find anything. And then a small study, not yet really published, though presented, done in 2020, funded by the Retirement Research Foundation, looking at using adult protective services to try to find what would be the scope of surrogate decision maker perpetrators. Guardians were included, and very little what we found about them. And then lastly, National Guardianship Summit papers on abuse. But again, more about the need, less about the prevalence.
Wow, it seems like there is a lot of information and research that was collected with this literature review. Can you tell me a little bit about what conclusions you drew from the literature review?
Well, as Pam said, we first looked at the extensive literature on elder abuse in general. But even with the abundance of studies and analysis, we still have difficulty to know how much elder abuse is happening, its nature, its causes, and effective preventive measures. And further, most of the literature on elder abuse fails to take into account the younger adults with disabilities, many of whom may have a guardian. And so trying to understand the nature of abuse by guardians, which is a small subset of elder abuse, is a puzzle for many reasons. The predominant puzzle piece is what definition should be used to describe guardian malfeasance. Is it defined by the terms of criminal statutes, or is it encompassed by APS definitions of abuse, neglect, and exploitation? Or is guardian misconduct something else as defined by standards of practice or statutory requirements, such as the timely filing of reports to the court? Our literature review tried to distinguish between possible systemic problems in the guardianship process, such as unnecessary or overbroad use of guardianship orders, and barriers to modification of those orders, and uneven monitoring from harmful or abusive actions by the individual guardian. The media exposés we examined tended to focus on sensational cases of intrafamily disputes that are being carried out in the guardianship courts. Though the one systematic review of media accounts that we included revealed that financial exploitation is more likely to occur through the misuse of powers of attorney and is more likely to be perpetrated by family members or caregivers who are not guardians. And finally, despite multiple national policy recommendations, substantial state legislative and court mandates, national court standards, and court guides for best practices, the existing literature really shows that there are many gaps between law and practice in addressing abuse by guardians. Our primary conclusion, really, from the literature review is that many questions have been asked about the nature and extent of abuse by guardians, but answers are very scant.
It's very interesting. So let's talk a little bit about the people that you interviewed. Who did you interview and what were you trying to learn from them?
So we were primarily interested in interviewing state court administrative offices. And although state court administrative offices have varying relationships with local courts, these offices are the central point of contact for the judicial information and data that we really needed to be able to describe the landscape of abuse and fraud by guardians. And to reach the right people working within the state court administrative offices, like I'd mentioned before, we leaned on the National Center for State Courts, which is a nonprofit organization whose mission is to improve the administration of justice within state courts. And the reason that we look to NCSC is because they manage the Conference of State Court Administrators, and they also maintain a directory of state court administrators or the equivalent official in each U.S. state and territory. And these individuals that they maintain a list of oversee guardianship issues as well as guardianship data. And they may also be responsible for managing state guardianship data systems, developing such systems, or at least framing the need for such systems, which is why we were most interested in talking with these individuals. And in interviewing them, we were trying to learn what data and information on guardianship they're currently collecting or would like to be collecting, and then what they know about collection of guardianship data at the local level.
Interesting. So, what did you learn from the interviews with court officials?
Well, it was clear from our interviews that guardianship data is so critically needed in two different ways. First of all, it's needed for individual case management and monitoring, tracking the cases. There's a need to track, for example, the due dates, the filing of the report, whether the report was timely filed, and so on. But there's also a need to aggregate data, get a bigger picture that would show overall trends and gaps. For example, the number of complaints, the number of denials of a petition based on the use of a less restrictive option, the types of guardianship cases, who the guardians are, and many other data elements. Clearly, all of the interviews emphasize the importance of court data technology on both counts. So it was kind of a matter of tech, and tech in some ways. But we first began by asking the court officials simply about what data they have on adult guardianship itself, regardless of abuse, because you can't effectively address abuse until you know how the system as a whole functions. So the bottom line to begin with is, do they know or can they readily get the total number of cases subject to court review in the state? Think about that, the total number of cases subject to court review in the state. That was kind of the lost ark that many have been searching for. Well, we found that it's not as straightforward as it might seem. So why is this so hard to know how many cases are subject to court review in the state? Well, first, states use different terms like active case, open case, and pending case that have different meanings in different states or even in different courts. Interestingly, some states say that a case is closed when a guardian is appointed, and yet, of course, we know that the case is just beginning. Second, the interviewees stress that it's important to look at whether the data that is entered is reliable, and that depends on who's entering the data and how they are entering it, and to what extent there is uniformity, kind of inter-rater reliability. And then third, there are significant differences among local courts. Counties may be kind of information silos. The uniform information can't be collected statewide. Some states talked about their lack of a centralized system. And then also, and this is really interesting, a lot of key information is, so to speak, trapped in the case file. I associate that term with Diane Robinson of the National Center for State Courts, and it's a very important concept. And it means, for instance, that the age of the adult or the adult's relationship with the guardian may be stated in the petition or the guardian ad litem report, but these documents may be PDF documents, and you can't do a query or aggregate information except with hours and hours of manual case-by-case searching. So it's just not accessible data. And then also, it's important to keep in mind that there are many other data elements besides just the overall number of cases. And Sally's going to talk about this a little bit later. A number of states said that they are aiming toward the gold standard in collecting guardianship data elements as set out by the National Center for State Courts. So then we went a little bit beyond just looking at guardianship, and we asked about guardianship abuse and fraud. What do you know about guardianship abuse and fraud in your state? And the interviews showed that data on the incidence of abuse is largely just not available without intensive case reviews, let alone data on the outcome of abuse and the real effect on people's lives. If you step back, you can see that courts learn about abuse through 4 different routes, but that none of these routes are sufficient. First of all, courts learn about abuse, of course, through guardian reports. And even though an increasing number of states are moving toward electronic filing, the rest of the states and many localities have reports and accountings that are submitted in paper form. They may be Word documents or PDF documents, and the information is not searchable and not accessible. And then 2, there are barriers in the review of the reports, not enough staff, not enough training for the reviewers, inconsistent review practices. And then courts also find out about abuse through complaints. Of those that we interviewed, 2 states said, yes, they had guardianship complaint processes, and 2 said they had a guardianship hotline. 2 said they were developing a complaint process, and 3 said they had forms to request a case review. And then also some states have a guardian certification process with a complaint system. We learned that there are very few allegations through the certification process, and many are not substantiated, or else they concern technical compliance issues. And then states said generally, whatever kind of complaint it was, they're not able in many cases, or they have insufficient resources to track the number of complaints as a data element. And then third, courts find out about abuse through adult protective services. But interviewees from just 5 states said that Adult Protective Services contacts the court when receiving a report involving a guardian. Others said, well, APS court communication varies locally. And then finally, courts could find out about abuse through court visitor programs, which are terrific, but of course they don't exist in all states and they don't exist in all counties. Some have active programs, but many just don't have such programs. And so courts summed up the barriers to finding out more about guardian abuse and fraud by highlighting lack of resources, burdens on guardians and attorneys, inaccessible information, coding problems, multiple local systems, and sometimes just plain old reluctance to change. So there you have it.
Thank you, Erica. Thank you for sharing just the sheer amount of data that needs to be collected as well as the challenges. So earlier you mentioned a survey. After the interviews, you developed this survey. Can you tell us about that process?
Sure. So in good research practice, we typically do interviews of individuals and then we work on development of a survey. So we take what we're finding in the interviews that we have, and then we try to make a survey from that so it better reflects the questions we want to ask. So we did that, and as is typical, conducted a pilot test to make sure it seemed clear to people. And then we emailed I think Carlisle talked a little bit about this, email the survey to points of contact from the National Center for State Courts, list of court administrative offices, and they had additional people. So we sent about 200, we sent the survey to about 200 individuals we believed who were knowledgeable about guardianship issues, monitoring, and data, and then kept the survey open from July to September of 2022. We know that 51 individuals at least opened or initiated the survey. And then of that number, 17 answered some or most of the questions and 17 completed the entire survey. So we know, as Carlisle said, among those who answered some or all of the questions, responses were representative of 20 different states. So we got to see about how the data collection was occurring, or abilities, at both state and local levels. But we had some limitations. And of course, it was that we didn't get nearly the response rate that we had hoped to. We were glad to get what we did, but we probably needed more responses to be able to say a lot of great things about what we have. So we didn't know whether it was the timing, the length, the complexity, or the people to whom we sent it. We did do standard protocol practice of sending it out several times, begging more each time, and so forth. So that's how we did that. That's sort of standard research protocols. We learned that a number of states, now the good news is a number of states can readily identify the total number of guardianship cases, which is better than it used to be. But there's, as you can tell, there's a long way to go to eventually be able to give numbers that we really need. So 14 states could readily produce guardianship cases subject to court review, but Erica told you the problems that are related with that. We learned that the most common data elements that states would like to collect go exactly like she said, inventory or accounting and annual report information, because that's the court's function. The other issues, or if there was a red flag about those, but other issues like what the age of the person was, or what the problems of the individual was, or how the guardianship was progressing, or where the person lived, those were not right. Those were not there. Also important, we learned that there need to be champions for improving guardianship. This is true for healthcare improvements as well. And when we asked respondents about that, generally the top three were something like the Administrative Office of the Courts, the Chief Justice, and national organizations. And the top person who was the champion position was the Chief Justice. Then we also took away that there were huge barriers, but the one that kept coming were overburdening court staff and insufficient staffing for data management. So we would say that court budgets would need to make a priority on collecting guardianship data and more finite guardianship data. so that it would make the monitoring function better, and it would be better to address abuse and fraud.
That's very interesting information, and it's great to hear that you had that type of response from the courts. What policy considerations did you bring into your research?
Well, we stepped back and looked at our research in a broader context. Our research is a snapshot, but guardianship law and practice is, of course, a moving target. While guardianship laws have changed substantially in the past 20, 30 years and continue to change, what we want to know about is guardianship practice, the boots on the ground. Now, guardianship is pretty unique amongst civil cases, in which, if you look at most civil cases, you see that once the court adjudication is done, the case is finished, all done. But with guardianship, once the guardian is appointed through the adjudication, the case is really just beginning and may go on under the court's supervision for years or even decades. And the court is not really set up for this type of extended oversight, especially where vulnerable individuals are involved. But on top of that, we have the complex nature of the court systems. Every state has some type of state court administrative office, but these state court offices have varying degrees of authority over local courts that hear guardianship cases. So that is the extent to which a state court is said to be unified, where there's a more centralized management and budgeting, including for data collection. Sometimes, as I said earlier, local courts are silos. And wait, there's more. There's whether guardianship is heard in a specialized probate court or in general jurisdiction court. In all but 17 states, guardianship cases are heard in general jurisdiction court, along with traffic and torts, divorce, felonies, and so on, and a whole range of other cases. And so guardianship is just a small sliver of the total caseload. Although in some, mostly urban areas, there are judges, general jurisdiction judges with considerable expertise. Now, here's the statistic. There are approximately 1,780 general jurisdiction courts with more than 7,000 assigned judges who hear a wide variety of cases. And so guardianship and guardianship abuse may simply get lost. And even with the specialized probate courts, a lot of their dockets are decedents' estates, so guardianship may be less of a focus than perhaps it should be. And finally, there's just the complex nature of abuse by guardians itself, which Sally so well described. Do we mean abuse as defined by Adult Protective Services, criminal abuse, non-compliance with statutes, violations of standards? Is abuse by guardians different from abuse that occurs in the general population? And is guardianship elder abuse different from guardianship abuse of people with disabilities? There are many, many pieces to this puzzle, as Sally said earlier.
Thank you for sharing those considerations, Erica. So what do you hope that the courts would be able to do with better data?
Well, we think that with better data, the courts will be able to allocate staff resources to monitor what we know is a proven rise in the number of cases and to justify to legislators why more judges, staff, court resources, and data technology are needed for effective case management and monitoring of the guardians that they have appointed, and to be able to spot and stop any abuse by those guardians. We hope that when courts have better data on their guardianship cases, they will better understand who is petitioning and why, especially if the petition was necessary to prevent ongoing suspected abuse, neglect, or exploitation. In such cases, the court would know to impose enhanced monitoring to verify that further abuse has been halted. Courts with enhanced data collection and analysis know how many guardians or family members who may not be familiar with court protocols and need special training on the unique responsibilities of serving as a guardian, responding to the court, and avoiding abuse. They readily know how many guardians are either diligent or delinquent in reporting to the court. As appropriate, courts with good data, they can set in place a tickler reminders to make sure those reports come in, or have staff investigate why the guardian is not complying or whether the guardian should be replaced. With data on how many complaints have been filed about a guardian's actions or inactions, the court gains an extra set of eyes on possible abuse and can take prompt steps to deter any abuse. Knowing at the individual case level and as a total amount, the assets that are under the court's supervision guides the court with data to the appropriate setting and review of bonds and targets cases with a potential for exploitation. Enhanced data allows the court to gain insight into whether orders are entered, the orders that are entered are fully justified, skillfully tailored to the adult's needs, and timely reviewed for the need to continue or modify the order. Creative courts are already using the data they are collecting to enhance their monitoring efforts as they stop and spot abuse.
Well, this has definitely been a very comprehensive report and study that you guys have done. So can you tell us what your final recommendations were to the federal government?
Well, of course, we have to keep in mind that the federal government doesn't do guardianship, and that the role of the federal government is somewhat limited because guardianship is clearly a state responsibility. But we tried to identify areas in which the federal government could aid, enhance, and fund efforts by the state courts. Now, we know that there is a new Uniform Guardianship Act, which takes specific strides to address the issue of guardian monitoring, of fiduciary responsibility, and the avoidance of any abuse or exploitation by either the court system or by the individual guardian. And some states are having a hard time wanting to adopt the many changes in the Uniform Act, which would create uniformity among the states because of the potential for the expense that the added requirements of the court in their responsibilities in entering the orders, in tailoring the orders, and then the court staff in monitoring the guardians for specific acts of abuse or neglect. And so we suggest that to encourage and enable the various states to adopt the Uniform Guardianship, Conservatorship, and Other Protective Arrangements Act, that they create grant programs that will help the courts enhance their systems as they adopt the Uniform Act. Another grant opportunity would be to the state's highest courts to support staff training and technology development to manage all those guardianship cases and the ability to aggregate those data. Currently, the Administration on Community Living is providing grants to the top court in individual states. Those grants have been very successful, in my view, in enabling the courts to develop data capabilities, but those grants need to continue. They're currently only reaching 10 states, and the expansion of those ACL grants to a broader range of states who are struggling with their data capability and technology is definitely something that the federal government can do to address the number of all the various problems within the guardianship system.
Continuing with the recommendations, our findings showed that key barriers to improving guardianship data so that we can better address abuse are, as Sally just said, lack of court resources and burdens on court staff. So state courts need funding to broadly evaluate their current systems, not just tech and not just training and not just for uniformity, but a really broad evaluation, including evaluations of due process, use of less restrictive options, the sanctioning of guardians who breach their fiduciary duties, and so on. We found 3 distinct channels for federal support of broad-based guardianship improvements. The first channel is through the funding of the part of the 2017 Elder Abuse Prevention and Prosecution Act, affectionately called EPA. So this might be a little in the weeds, but part of EPA specifically focuses on guardianship oversight and activities, and that's good, but unfortunately it has not been funded. So there's a funding opportunity and channel. The second channel is, as Sally said, through the continuation of funding for state guardianship reform efforts broadly. The State Justice Institute has funded some pilots. Both the State Justice Institute and the HHS Administration for Community Living have funded WINGS grants, that is, development of state working interdisciplinary networks of guardianship stakeholders. And as Sally said, ACL has funded 10 states with substantial elder justice innovation guardianship grants that look broadly at the capacity of courts to collect and aggregate data to improve monitoring and address abuse. And certainly those are underway now and should be continued. However, those will end at some point, the individual grants to the individual states. And what it seems to be, perhaps certainly in my own personal viewpoint, most important here is that the funding be ongoing. And so we looked very hard at the idea of Congress funding a nationwide guardianship court improvement program. Now, to show what that means, you have to look at the child welfare field, and you'll see that in child welfare, there is a court improvement program, and the parallels are quite, there are many parallels between guardianship, adult guardianship, and child welfare. But in the child welfare field, the federal government has been funding the highest court in each state for child welfare reform since 1993. So those highest courts get regular ongoing support to build state court capacity, conduct assessments, and make improvements. And therefore that program has achieved significant results. We think a similar ongoing model for adult guardianship, which was one of the key recommendations of the 2021 Fourth National Guardianship Summit, is really a key to change, because as we've emphasized throughout, change is constant. The change in this field is rapid. Turnover is constant. And so we need something that's going to focus on guardianship improvement that's stable and ongoing.
So another one of our recommendations was expanding federal data sources to include guardianship. So what they've got already, they could add to. And we know very well that the federal government collects information through lots of key databases concerning health, long-term care, criminal justice, and fiduciary and legal services networks. And we think they could have a potential for including or strengthening data elements on guardianship. One of these would be the National Adult Maltreatment Reporting System, or NAMRS as it is called. And we think the federal government should continue to provide grants to state APS services to enhance their ability to collect and report data on any relationships between the victim and the person perpetrating the abuse, including fiduciary relationships such as guardianship. We also think that the Social Security Administration and the Department of Veterans Affairs could also address abuse and fraud by guardians, adding into their databases that they already collect. They work with other federal agencies we know on behalf of veterans and should address barriers to information sharing concerning representative payees and fiduciary cases. Then we think that other federal databases hold varying degrees of potential for learning more about guardianship and the scope and prevalence and nature of abuse by guardians. Where feasible, we think federal agencies could modify their current crime, criminal justice, health, long-term care, and legal service databases to include information on guardianship and abuse by guardianship. And one really great way to work with a number of federal agencies would be through the Elder Justice Coordinating Council that is already set up, working with DOJ and ACL.
And then I'll also mention there's a need for a coordinated response amongst courts, adult protective services, and law enforcement so that there's more structured communication and collaboration between these entities. And the Department of Justice could partner with the Administration for Community Living and really take the lead in convening these key stakeholders to build an infrastructure around communication to better target abuse by guardians. And while this is not necessarily a data initiative, it would help inform data in a valuable way.
Well, thank you again, Erica, Sally, Pam, and Carlisle for joining us and talking about your report. If you're interested in further information on this and other topics, check out our podcast notes on our website. We will also have a link to this report as well as bios for Erica, Pam, Sally, and Carlisle. You can also listen to this and other episodes by visiting the ABA Commission on Law and Aging's website and our YouTube channel. Remember to like and subscribe to be sure to get any updates. We look forward to having you join us for our next episode. In the meantime, keep on advocating for the legal rights of all.